Thank you, Your Honor. Thank you for this opportunity to discuss the University of St. Thomas's erroneous discipline of John Doe. In doing so, it's important to note a couple of key points. First, John agrees with the district court's holding that UST owed John a duty of care under Barrio to provide fair and impartial disciplinary proceeding with appropriate due process protections. Second, the court should disregard UST and the Minnesota Private College Council's false claim that the district court ruling opens up litigation floodgates. This is false in part because the U.S. Department of Education's recent regulations already mandate the common sense due process protections UST denied John. It's also false because the district court, like dozens of other court decisions cited in John's brief, accurately determined that he said, she said, Title IX disciplinary proceedings impose greater duties on universities than those required in other types of disciplinary proceedings.
Mr. Rosenberg, just a quick question. I think you said the court held that there was a duty. Did the court hold there was a duty, or did the court assume there was a duty?
What the court did was they applied the Barrio and Rollins as finding a duty based on due process and evaluating and a fair and impartial proceeding. So the duty or negligence duty was identified as including due process, fair, and impartial proceeding. In this case, this did not occur because there's a systemic bias against accused students like John. We know this in part because UST trained its employees that there's almost no chance that accusing students might make unfounded allegations of sexual misconduct. For instance, UST trained its employees that accusing students are telling the truth even if they provide inconsistent explanations for their alleged assault or deliberately omit details such as exculpatory evidence. Now, this training is built on the premise that accusing students' inconsistencies are caused by trauma and therefore cannot be used to establish the untruthfulness or lack of credibility. But a peer-reviewed academic journal noted no available research supports this premise, and the type of training UST utilized causes investigators to become biased with presumptions of guilt. Now, in this case, we've cited 6 court decisions that found students like John can establish actionable bias based on their university's biased training materials. And these decisions speak to the core of the breach in this case because UST's training is completely devoid of how to ascertain whether Jane's contradicted testimony occurred because she was lying or because of alleged trauma. And in this case, the district court properly acknowledged that UST manifests a bias in favor of accusing students that cut against accused students. But the district court appears to have erroneously excused this bias because it was looking for gender bias. This was an error because UST's breach of its duty can also be based on UST's bias in favor of accusing students. Now here, John did establish this bias because UST repeatedly failed to question Jane about inconsistencies that supported John's innocence. For example, Jane was never questioned about her roommate contradicting Jane's allegation that the roommate would not have heard John slam Jane into a bathroom cupboard because the roommate was sound asleep. UST knew Jane's allegation was suspect because Jane's roommate testified that not only was she awake, but that she talked with Jane before Jane entered the bathroom without knocking to join John, and that the roommate heard no sounds or disturbances coming from the bathroom. Similarly, Jane was not questioned about her false allegation that she was so afraid of John that she double-checked the exit door of the building to make sure that John could not get back in. She knew this was false because a surveillance video of this exit door proved it never happened. And many other examples. If you look in the record, the fact finders exchange an email which they say, we really need to get Jane to commit to telling the truth like we did to John. We have to ask her these questions because her answers could impact her credibility. But when you read the notes from the interviews, you see that that never happened. For example, Jane provided, instead of answering questions, provided a bullet point presentation of her allegations against John, and the investigators, adjudicators never asked her to explain the contradictions between that bullet point and the first interview, or the bullet point and what she said to the police. You have evidence that they were trained, the investigators, adjudicators. For example, one knew that the normal process to address someone's problem is to ask them follow-up questions, but that he never asked Jane to address the problems in her testimony. Another explained that the other investigator said that her job was really to let Jane tell her story. This is all based on the training that's debunked by the six decisions I've discussed, as well as the peer-reviewed article. So reasonable jurors would likely find the totality of the unasked and unanswered questions discussed in the briefs violated UST's duty because UST trained its employees to view accused students through a collective guilt lens. And to prohibit John from exposing this collective guilt, UST uses what's called a single adjudicator model, which is now under the new U.S. Department of Regulations prohibited. But this single adjudicator model allows one group to serve as the police, prosecutor, judge, and jury, while simultaneously denying accused students live hearings and cross-examination. Now, UST wants to continue to implement this biased proceeding, even though it violates U.S. Department of Education regulations and runs afoul of upwards of 25 court decisions that mandate cross-examination in he said, she said cases. Therefore, we would ask this court to reverse the decision on a negligence case. In addition, one other issue that's raised in our brief I want to cover quickly is that
Counsel, could I ask a question on a different issue here? I'm wondering, and this may be a little out of left field, but what your damages claim here would be. And that the reason I'm asking is we're here in diversity jurisdiction. How do you get over the 75,000 threshold given the facts of this case?
Well, you have the pain and the suffering issues as well as the out-of-pocket lost scholarships, as well as expert.
But wasn't the scholarship revoked because of grades?
Well, the scholarship, he was kicked out of the school, so he can't come back. So the loss of the scholarships are recurring, so that's part of the issue. The issue also here is that, had this case gone to trial, whether there would have been expert witness testimony about lost wages or the missed academic time, those are issues that aren't before the court and really wasn't raised specifically in the briefs. But there is enough damages here to show that this should have gone to the jury. That would be essentially an issue of material fact, I would say, Your Honor. But on the issue that I was going to raise with you is whether Jane should have been deposed and whether the court abused its discretion. I do believe it's important to acknowledge here that although UST did not raise these issues in an amicus filed by Jane, did raise meritorious waiver issues related to Civil Rule Procedure 72. We would ask that the court determine that since UST didn't raise these arguments, that they waived the right to do that, and that the court find that there was an abuse of discretion in not allowing John to depose Jane in response to the summary judgment motion that was filed, because there was hearing testimony on the motion to compel issue that discussed how John needed to depose Jane about the negative issue because the investigators were alleging that they didn't remember what happened in the interview, so he needed to depose Jane. So on the last issue that I have in front of this court, if you have any questions, I'd be happy to answer them. Otherwise, we would ask that the court reverse the district court's dismissal of John's negligence claim, because reasonable jurors would likely find that UST's biased Title IX procedure violated the duty under Barrio, because to do otherwise would allow Minnesota private universities like UST to violate the duties of care and erroneously brand students sex offenders, thereby destroying their reputations, their educational options, and their future employment opportunities. Thank you.
Thank you, Mr. Rosenberg. Board will hear from Mr. Schooler.
Thank you, Your Honors. David Schooler, representing the University of St. Thomas. And we agree with Judge Stuenheim's decision to grant summary judgment, and we believe that St. Thomas has demonstrated that they conducted a fair and impartial investigation consistent with their policies and procedures, and that they acted in good faith. However, the focus of our argument today is on what we view as an expansion of the law that's impermissible by the United States Supreme Court. And what we want to focus our argument on is what was the state of the case law in Minnesota before Judge Thunheim made this decision at the district court level. And we believe that there's well-settled case law that goes back 100 years, and that is a very limited duty, and that is a duty for colleges and universities not to expel students arbitrarily. That is the state of law. There was nothing else regarding negligence, reasonableness, or anything like that. And I think if we look closely at the case law, and we're talking first Davis Monroe, which is the highest court in the land, basically stating that courts should stay out of the business of second-guessing universities, and especially private universities. And then we have Avario and the Rollins case, and those are the two cases that we believe that the district court misinterpreted. And let's go back to what we believe the district court did in committing error. We believe that the decision that Judge Thunheim has issued regarding the duty and the expansion of law is contrary to precedent, and we also believe it's bad policy. And when we talk about opening the floodgates, we truly believe this is a case that opens the floodgates. Attorneys overuse that phrase all the time, but in this particular case, you have a reasonableness standard where every single dispute can suddenly end up in federal court. Let's talk about what Judge Thunheim did in interpreting these cases. And when we're looking at the cases, there tends to be two kinds of discipline that we have buckets for. One is academic, and the other one is non-academic. And in the Avaro case, it's either you can meet the 2.0 threshold to be in Hamlin Law School, or you can't. And in that particular case, there was a decision that the student was properly expelled because he couldn't meet the thresholds, and they did not do so arbitrarily. They acted in good faith. That's an easy case. Judge Thunheim seems to suggest that the Rollins case was somehow different. The Rollins case involved impermissible emails, so that was a non-academic case. And in Rollins, the court clearly and unequivocally stated Minnesota law, and Minnesota law states the same has been the precedent for the last 100 years. You cannot arbitrarily expel students. Judge Thunheim seems to indicate that there's an expansion of the law, and we believe he's in error. And in fact, if you look closely, you'll see that the court in the Rollins case quotes an Iowa case that talks about something more than an arbitrary standard. They talk about a reasonableness standard, and we believe if you look at that Rollins case, that is rejected. And to the extent that Judge Thunheim implies that duty, we believe he's wrong. And that is an expansion of Minnesota law. The panel asked a question about whether or not that duty exists or it's implied. If you look at Judge Thunheim's order on page 11, I think this is the Achilles heel of where he expands the law well beyond what the United States Supreme Court says that a district court judge is allowed to do. And I quote, and on page 11, Judge Thunheim states, thus, when the Supreme Court stated that, quote, the requirements imposed by the common law on private universities parallel those imposed by the Due Process Clause on public universities, end of quote, it necessarily implied that something more than an arbitrary standard would apply to university discipline standards, disciplinary actions based on student misconduct. We don't believe there's any implied duty in there, and to the extent that it was discussed in the Avario case, it was dicta. So this represents a significant expansion of the law, and we don't even have an arbitrary standard now. We have a reasonableness standard, and not only do we have a reasonableness standard, we have a situation where that is not discussed. And so we have a standard without any parameters, which generally makes bad law. And that is where we think this court should affirm, but should change this law to go back to the well-settled Minnesota law. We also think it's bad policy, and there's a number of reasons why it's bad policy. One of the primary reasons that it's bad policy is because courts are now in the business of interfering what is largely an academic matter, and that is how do we discipline students. And how they do so individually has largely been left to the institutions. And in this particular case, the amicus brief, as well as our brief, point out that you have many private Christian faith schools in Minnesota. University of St. Thomas is one of them, along with St. Olaf and Augsburg and Hamlin and others. They are faith-based institutions, and the court shouldn't get into the business of doing that. And we believe that it's bad policy to do so. And we also want to note that private colleges have individualized missions and values. St. Thomas, for example, is a mission-driven institution that is faith-based. This identity shapes its unique educational objectives and desired campus culture, policies, and processes. And in this particular case, you have to understand that the university did not expel John Doe. In fact, what they did is they gave him a 3-semester suspension, after which he'd be allowed to come back to school. And in this particular case, as part of the record, the sexual misconduct was not the first issue that he'd had. He had a number of run-ins with the school already involving alcohol consumption, inappropriate comments to students. So here was a situation with John Doe where they said, we're essentially going to make you sit on the bench to reflect. We want you to reflect on your Catholic values, and afterwards, you can come back to the school. That was the discipline that St. Thomas came up, and that was after a fair and impartial process. And we think it's bad policy for district courts to get into the business of second-guessing what St. Thomas did. For this reason, we ask that the court roll back the expansion of the law and affirm on the additional grounds. In addition, if you look at the breach, we believe there's no breach. And you have to look at what St. Thomas did at the investigative level. As soon as John Doe received notice of the report by Jane Doe, he was immediately advised of that, and he hired an attorney, Mr. Beau McGraw, who was involved every step of the way. And this was a thorough and impartial investigation. During the course of the investigation, John Doe was able to identify witnesses. John Doe was able to introduce documents. John Doe was able to introduce other evidence and suggest particular questions to be asked of all of the witnesses, including Jane Doe. And John Doe was interviewed twice, including having an opportunity to react to Jane Doe's testimony. And John Doe's lawyer was accompanied throughout the process and was present at his interviews. And the allegation that he wasn't allowed to depose Jane Doe, we believe that was waived at the administrative level. Nonetheless, that is not allowed by the policies and procedures in University of St. Thomas's handbook. And in fact, even in public universities, they are not required to allow the cross-examination. And if you think about it in a practical manner, think about not only a sexual misconduct hearing, but every single hearing involving disciplinary proceedings. How do we handle this? We have lawyers coming in and cross-examining somebody about cheating an exam, getting in a bar fight. Any single grievance or misconduct that could be disciplined, you now have Beau McGraw, who is a trained criminal attorney, or somebody similar to him, coming into the college and university and cross-examining a Jane Doe or other witnesses. That is exactly what colleges and universities across the country don't want, and courts have not allowed that.
What's
after there was this,
if I may interrupt, how do you respond to the recent citation of the John Doe versus University of the Sciences case from the Third Circuit?
And what was the site again? The John Doe versus the University
of the Sciences from the Third Circuit.
I've read all of these cases several times. I cannot remember the exact holding in that case. I would have to have my memory refreshed.
Well, you might want to look at it someday if you can break away from what other duties you have with your firm. Or the Seventh Circuit case, Jill versus Purdue University.
Yeah, I think the difference here is the narrow ruling of Minnesota State Court law, and what the Avero case and the Rollins case have stated. And I think the critical point there is we have very limited duties in the state of Minnesota, and I think those apply to different state law than Minnesota, and I think that's a distinction that we've made in our brief as well.
Back to the Mr. Rosenberg we're talking about, what is the current status of the Title IX regulations?
The current status of the Title IX regulations, obviously they've changed.
I'm sure you read Erica L. Green's May 6, 2020 article on New York Times about DeVos's rules bolster rights of students accused of sexual misconduct.
Yes, I have, Your Honor. And, our position is that, the groundwork has dramatically shifted. There's no doubt about it. But as far as the rules and the laws as they relate to the law back at the time that this investigation was conducted at St. Thomas, and the administration fully complied with all the rules and regulations at that time. And we don't disagree that the landscape has changed, but as far as the investigation at that time, we believe they were consistent with the law at that time.
Unless, of course, there are constitutional duties beyond the law.
And we don't disagree that if there were constitutional duties, that obviously we would follow those, but we believe that the university followed those, and the due process, which does not apply to private universities, is something that I think is a significant distinction in this case as well.
Mr. Schooler, do you have any reaction to Judge Kobus's earlier question about the amount in controversy here?
That raises an interesting point, and we raised it. We didn't raise it quite in the same context, but we have indicated that we do not believe that he has damages. He was not kicked out of the school, as counsel points out, but rather suspended. And his GPA in the first semester was already an issue. So whether or not he was going to maintain a scholarship is something that needed to be determined. But he had a certain GPA he was required to be at to maintain that, and he wasn't there. And as far as the monetary damages, we believe you have to post some level of monetary damages, and we don't even think he can post a single dollar. And as far as the manner in which he's seeking to claim emotional distress damages, that's contrary to Minnesota law. And there's the Carlton decision in which Judge Schultz points out that you need to have an actual physical injury, which he doesn't have. So getting back to that, we think that's another alternative basis for which the court could determine that there is no damages, and the case could be reversed in that as well, or denied, excuse me. And then finally, and I don't
necessarily think that would be the result. I think the result would be a dismissal for lack of jurisdiction.
You know what? I believe you're right on that. Lack of jurisdiction, you're correct.
What was pled in terms of damages? Was there a specific dollar amount pled?
No, it was the minimum. I believe it was, and I'm looking at my associate, I believe in the amended complaint, it simply stated that there was greater than $75,000 in damages, but no specific number.
All right.
And I see I've got 33 seconds, so I'll hit on this final point, which is the expert testimony. In this case, it involves professional services, essentially, professional judgment. This case is no different than whether it's an accountant, a lawyer, or any other professional services in the state of Minnesota. You have to have an expert testify to that. And in this particular case, John Doe did not indicate or notify or disclose an expert witness, and rather what he wanted to do was jam in articles, which he would have no way to get into evidence. So we think that would be another way that the court could affirm the decision on alternative grounds. Thank you.
Thank you, Mr. Schooler. Mr. Rosenberg, I believe you have a little bit of rebuttal time.
Thank you, Your Honor. Well, first, opposing counsel spent the lion's share of his argument talking about reversing the district court. There's been no cross appeal here, so USC has waived the ability to collaterally attack the judge's decision. I'd reference the court to the Jennings, Gross, or East Iowa Plastics case on that issue. With regard to the question about what the district court did being totally out of sync with Barrio or Rollins, that's an incorrect reading of both the district court decision and Barrio and Robbins. What the district court is really just a natural application of Barrio and Robbins by looking to due process and evaluating what qualifies as fair and impartial Title IX proceedings. And there's no opening of the floodgates here. There's no second guessing. Those arguments don't really hold up for many reasons, as I've said earlier. One is that the U.S. Department of Education has already passed regulations that prohibit UST from doing what they're asking you to do today. And there are over 30 court decisions cited in the briefs, in John's brief, that talk about how due process protection apply an extra dose of these in Title IX proceedings. It's very important to look. I think that you mentioned the University of the Sciences case. That's a Third Circuit decision that came down and basically said in a contract case that we are going to superimpose cross-examination into this proceeding, even though the policy doesn't have it there, because it's required for a fair and impartial proceeding. The upwards of the 25 court decisions that I'm referencing, most of them and many of them address whether you have to defer to universities and found that you do not have to defer when there are constitutional violations, even at private universities. I'd ask the court to look carefully. We cited 7 different decisions that say due process protections to cross-examination apply in private universities. 4 of those are another state that apply a very similar doctrine to Minnesota in looking to due process. Similarly, the UST's academic freedom argument is rather fickle. They supported the previous administration's regulations and everything that they couldn't do, but now under the current administration, they want to say we don't want to do that. It's really a taking into two argument. And it's important because, as referenced, Secretary DeVos, when in discussing the state of these proceedings, called these kangaroo courts. Why? Because of the single adjudicator models I've described to you. John Doe, now, USC claims that John had a right to cross-examination. That's not in the policy. You can ask witnesses. It doesn't say to ask the complainant. And there's no hearing. There's no process to do that. It precluded due process from happening. And that's what Barrio and Rollins looked at. Yes, they were not Title IX cases, but they were cases that applied due process protection. I want to try to get through the last couple. I think I have maybe a minute or two. The 3-semester suspension, and there was discussion of a psychological harm that happened to John on top of that, but that is lost wages, calculated out later at trial. The expert witness testimony argument was addressed by the district court and rejected. Essentially, I would ask the court to look carefully at the training materials that are in the case. They are devoid of any discussion on how to evaluate whether accusing students' allegations are false or based on trauma. They are devoid of any training on how to provide a fair and impartial process. They say just the opposite. They teach you how to convict the accused student. It's a two-tiered system at USC where if you're an accusing student and you make contradictions, you're believed as truthful. If you're the accused student, you're the same, you're believed as untruthful. That violates the duties under Barrio and Robbins in a district court, and I ask you to reverse the court on that issue. Thank you, Your Honors.
Very well. Counsel, we appreciate your appearance and argument and cooperation in helping us set this up. Case will be submitted and decided in due course.
Thank you.